give them a couple of minutes to who's joining.
Sure, sir. Sir, with your permission, we would like to now start.
Sure, no problem. Go ahead.
Yeah, we are live on YouTube and Facebook as well. All right. Good evening, everyone. I, Fariha Ali Khan, on behalf of Asia Pacific Vis Moot organizing team, warmly welcome you all to today's session on research for Vis Moot. What makes the first Asia Vis Moot unique is that it is one of a kind and inclusive of everyone's participation. The ideology behind this moot is to step out of the ordinary and provide an exposure for holistic development and learning. This is an exciting new competition that aims to give training to young budding lawyers and students to improve their skills in advocacy and arbitration. This pre-moot will be an essential part of the training for the students and arbitrators planning to attend the Vis Moot and the Vis East Moot. The skills learned here will also be a key component for future careers in arbitration. For today's session, we welcome our interpreter, Ms. Monica Punjabi. Welcome, ma'am. And as the keynote speaker, we have Mr. Lavesh Kirpalani. Sir joined Prince's Chambers after clerking at both the Court of Final Appeal and the Court of Appeal. He has a broad-based civil litigation and arbitration practice. He has experience in a range of cases involving areas such as general commercial, insolvency, company, white-collar fraud, etc. He was ranked in the Legal 500 Asia Pacific 2021 for commercial disputes, and currently he is a visiting lecturer in the University of Law, Hong Kong campus. Lavesh sir has also been a Vis champion as well. Sir, I'm sure the attendees are waiting to hear from you. So without taking up much time, we welcome you, sir. The floor is yours.
Hi, good morning, good afternoon, and good evening to everybody, wherever you are in the world. At the outset, I just want to say a quick thank you to Dr. Sharma and the members of the Asia Vis Pre-Moot for inviting me to give a talk on this topic on how to conduct research for the Vis Moot in particular. You will find that research is a valuable skill regardless of what walk in life you eventually choose to go on, but just how you progress in life and what you need to discover. So without further ado, let me talk a little bit about the background of the Vis Moot and how I found research to be a valuable skill that I learned and developed as I've gotten along. So let me just share a quick slideshow with everybody so that you can have an understanding of what I'm talking about and where I'm going. Give me 1 second. Let me just share the screen. All right, let's try this again. All right. Can you all see the screen on board here? I hope so.
Yes, sir.
All right. So the first thing one needs to look at is what is the starting point when doing research? Where do you start? Now, all of you by now would know that there's the moot problem. And that's honestly the first place you have to start looking. You need to go through the moot problem and read it from start to finish. Now, there's a trick to reading these type of documents. The trick is don't read it line by line and do not highlight every single line. What you want to do is read the document from the first page to the last page. Once you've done that the very first time, you'll have a better understanding of what exactly is being asked of you. The difficulty that most students have is they try to understand how each item is relevant immediately and don't focus on the bigger picture. the starting point is you need to have a big picture understanding of what you're doing before you can eventually develop into the understanding of each little aspect of the case. So you first want to be able to understand what the facts are. Once you've done that, you want to be able to learn what the legal issues are. Now, obviously, that's a bit difficult if you don't have any background in commercial law or arbitration law. And I'm going to come to that in the next slide. And once you're aware of what those legal issues are, you want to be able to do research or conduct research on relevant jurisdictions and see maybe there's more than one jurisdiction or more than one area of law that might be applicable and conduct research in that area. So in general, you have primary, secondary, and tertiary sources of information. Now, they're all available mostly online nowadays, and hopefully most students these days have access to a lot of these items. If you don't, there's always the backup place where a lot of students can go, which is their law library or their law library website, obviously. And hopefully with those resources, you'll be able to conduct the research you need. And I'm going to go through and explain how best to conduct research using those sources. So as I mentioned earlier, if you don't have any background understanding or knowledge of arbitration and commercial law, there are certain things you can do. The first thing you need to do is just find the main textbooks in that area of law. So you want to be able to find a textbook on arbitration law. So you might want to go to the library and look up Redfern and Hunter on arbitration. It's a basic text. There's a student version as well. And it'll just give you a core understanding of what the key issues in arbitration are and how arbitration law works. For the Vis Moot, you also, before you really get into your research, want to just have a quick read of the UNCITRAL model law, the New York Convention, and the CISG, which is a convention on the international sale of goods. Sometimes referred to as the Vienna Convention, has many different names, but you want to get through and read all of them. Once you've done that, you need to start looking into what are the relevant databases that are available for you and familiarize yourself with them. And honestly, one of the biggest issues I found when I'm teaching in law school is that not enough students take the time to familiarize themselves with those legal databases and practice using those databases. So you just want to take the time and play around with it. You want to do as many different types of searches as you can, and you want to see what's in there and what's not in there. For instance, I have several students who didn't realize that on the Westlaw database, that there is actually a section where they have textbooks. And those textbooks are numerous and have tons and tons of relevant information. If you actually take the time and you go through it, you might actually find there's something that's highly relevant there that you didn't know you had access to. And as I mentioned earlier, it's always important to remember not to forget that libraries still exist, whether it's your university library or state library or country library, whatever it is. Maybe it might even be the judiciary library. Take the time, take the opportunity, go and look at those places, make sure you have access to them, and make sure you take the time to look through and search and just explore. So that brings me on to some of the important databases that students should look at. So there's 3 of them that are legal, and then the 4th one, which I think is underrated and underappreciated. So obviously you have Westlaw, run by Thomson Reuters, Sweet Maxwell, and it's an excellent resource for doing legal research. You have LexisNexis, which is equally very useful in terms of doing research. And then you have Kluwer Arbitration, which is probably one of the best resources for arbitration research. Now, I know not every university or every student has access to those databases. However, if you do, you should make best use of it, especially Kluwer Arbitration, which actually has some of the most prominent arbitration textbooks out there included within the subscription. A textbook that every student should be aware of or know about is Gary Bourne's Treatise on Arbitration. It's onto its third volume, and it almost covers every single aspect of arbitration law there is. Now, separate from those three databases, there is Google. And Google is by far the best tool there is. Even if you don't have access to those databases, you will find what you're looking for if you search hard enough on Google. Don't forget, Google's linked with Google Books. It has articles and Google Scholar. So you can actually go through that and look for extra stuff. Now, separate from those four databases, you want to also be aware that there is a CISG case digest, which is available on the CISG website. And there's also a case digest for the model law. Both of those are going to be relevant in terms of just doing general research on each provision of the CISG and what cases are applicable to them, as well as for the model law. And I'm just going to make one brief mention of a very important textbook that you should read or have access to if you can, which is Holtzman and Newhouse on the New York Convention. And they actually go through the entire drafting history of how the New York Convention was formed and developed. And it's worth taking the time to give you a better understanding of how each of the different provisions of the New York Convention work and developed into being put into legislation. All right, so I get asked all the time, how do I conduct research so quickly? One of the best tools I've ever been able to come across is Boolean search operating terms. So what is a Boolean search operating term? So it's a term which allows you to connect your search terms together to narrow or to broaden your search results. And in the next few slides, I'm going to go through each one and explain which one broadens it and which one narrows it. And it helps you find exactly what you're looking for. And in a lot of instances, it yields more accurate search results. And I'm going to go through which ones are the ones I use the most and which ones I think are the most useful. So the most common Boolean search operators are and, or, not, and quotation marks. I tend to use and quotation marks the most. I find them to be the best in terms of narrowing searches. So let me take you to the Boolean operator for and first. So and lets you search for items that include 2 or more keywords. And sometimes you can use and for 3 or 4 keyword searches if you want to narrow it even further. So and is used to narrow down searches. It ensures that the search keyword that you found, the initial word that you're looking for, and the second term line up together. And only results showing both those keywords come up. So for example, if I was searching for Tom and Harry, then all my results would have both the words Tom and Harry. I wouldn't have to worry about whether I'm just finding the word Tom only or Harry only. So for example, if you're looking at an issue in arbitration, you might want to put arbitration and whatever the next term is you're looking for. When I did the Vis Moot, it was removal of counsel. And I put those in quotation marks, which I'm going to explain how that works in the next few slides as well. The next Boolean operator that is used by a lot of people is or, but or is something that actually broadens the scope of your search. So or is what you use when you're trying to find 2 alternative keywords. And you want to make sure that you're covering both of them. So as you'll see from the diagram on the screen, if I search for Tom or Harry, I would get either the words Tom in every search I did or Harry in the search I did. And it's very expansive. It requires then that you would have to read through thousands and thousands and thousands of searches, which honestly is not abnormal in terms of doing research. When I did the Vis Moot, I probably read about, and I didn't read them completely, I skim read most of them. I would say 1,500 to 2,000 authorities in total over this period of about 6 or 7 months. And then the other one, which is extremely useful, is the Boolean operator not. So not lets you exclude keywords from your search results. So for example, if you're looking for arbitration, but not litigation, you put arbitration, not litigation. It narrows down the searches and makes sure that particular word doesn't show up in any of your searches. This is extremely useful when you want to make sure what you're searching for is extremely specific. So it's very narrow in terms of what you're looking for. As you see on the screen there, the example I gave was Tom, not Harry. Now, this brings me to my favorite Boolean operating search term. So it's the quotation marks. Now over here, I've just put in lorem ipsum just as a random phrase that you'll find whenever you're using Word documents, and it just comes up as a generic empty text. So if I wanted to find that exact phrasing, lorem ipsum, I would put it in quotation marks, and those exact words and exact phrasing would show up in any search I conducted. That is probably my favorite search tool, and it's the one I use every day. You will find that when you use the quotation marks, that you need to be quite careful about the words you use to type in. Because for instance, as I mentioned, the phrase example I gave was removal of counsel. You might also want to search in quotation separately from that, counsel was removed, or any other alternatives, because when you're using the quotation marks, it's that exact phrasing that comes up. Nothing less, nothing more. Now, this brings me to the Boolean operating search term, the asterisk. It's not one I mentioned earlier because it's one of the harder ones to use, but it has its own advantages and benefits. Now, it's sometimes referred to as the wildcard or the truncation search term operator. And so Boolean uses this where you have, say, for example, a few letters, and then you want to make sure that you can find different variations of it. For instance, if I wanted to look for the word feminist or feminism, I would just put femin and then an asterisk. And that would allow me to find the different alternative phrases that have F-E-M-I-N to start with them. Now you'll see at the bottom of this screen, I've given the example of H-A-R because we were referring to the different examples of Tom, not Harry, or Tom or Harry. And so if I put H-A-R asterisk into my search, I would get multiple and many different variations of words that follow H-A-R. For example, Harry, Harriet, harmony, which is not even something I would be looking for. So you want to make sure when you're using the asterisk, you're using as many letters initially to form the sentence or form the word, to ensure that you have a limited amount of results which come back in return. Now, where does that take us? Once you've learned how to use these different types of Boolean search operating tools, it comes to about how to master the skill of using them in conjunction with one another. So for example, as I said, I love using and I love using quotation marks. I'll put different phrases in a quotation mark, put an and then join that together with another quotation mark with something else included in it. It narrows the search down greatly. Also, since some databases automatically put in a truncation search, for example, if you use hklii.hk, which I use all the time for Hong Kong legal research, if I search the word happy, for instance, it would also show up in terms of in its own internal search engine, happiness and other words which starts with HAPP sometimes, because they have their own built-in database which does that. And sometimes I don't want that to happen. So I'll even put a single word sometimes just into quotation marks and use that in conjunction with the and or not. All right. So those are some of the tips and tricks you can use in terms of going through databases, doing searches, and trying to find all the relevant authorities, cases, or treatises that exist. Now, that's all wonderful and great once you've done that, but the question is, what do I do with all of it? You want to be able to manage your research. So you want to keep a copy of all the items you've searched and you've found relevant. My personal tip is make a folder on your computer and just call it research folder. And as soon as you find something you think it's relevant, just save it into that folder and keep it there. You'll always be able to go back to it. And if you have a good enough memory, you'll usually be able to remember on around what day and what time you found it. Now, if that's not something that works for you, make sure you rename each of the different things you found, give them a keyword, a name, an initial, whatever it is, so that you can go back and find that particular piece of research you thought was relevant. Alternatively, you can make subfolders, and for each different relevant point of law, you can save each relevant item in that subfolder. All right, so this brings me back to something, or one of my pet peeves with regards to legal authorities and how to read them. So I teach at the University of Law, I was mentioned earlier, and one of the issues I come across is that my students tend to just jump into an authority and start highlighting and reading the whole authority and highlighting each line one by one, underlining every sentence. And what you get at the end of the day is just a multicolored piece of paper. And it doesn't mean that they've actually understood what they've read. What you want to do, in my personal opinion, is to skim the document for the first time. Don't highlight it and do not underline it. Just make sure you've read it and you've understood it. Understand what the document is telling you and what you're looking at. If you're doing lots and lots and lots of research, get to the key part which you're looking for by, first of all, just doing a quick search or find function and finding that key term and reading that part, at least in full and as quickly, and skim over it as quickly as possible before you go back and reread the entire document. Now, once you've come to ascertain that that particular piece of legislation, authority, case, research, whatever it is relevant to you, you want to go back and read it again in more depth the second time. Now you can bring out your favorite multicolored highlighters, your underlining pens, whatever you like, and go through and make sure you're highlighting what's relevant to what you're trying to find. Now that's just the beginning of how to get through looking through the one piece of authority that you have. The next step is to go even deeper. It's to check what the underlying authorities that are cited within it say, to make sure that what you're saying is congruent and tracks with what the law was and is. And you still want to check if the authority, case, legislation is still good law. So if you go on Westlaw or LexisNexis, for instance, you'll usually have a little question mark or a little green signal or red signal telling you that the law is still good law, it's being overturned, or it's being considered. Sometimes you might also need to check whether or not it's currently on appeal and whether or not it's still going through the court system. And once you know that, you need to flag it and remember to go back and eventually check in on what is the status of that case. Now, all of that's well and good, and it takes you through all the different types of ways that you can conduct research and gather your research results. But you have to remember, persistence is what you need to do for research. You have to be persistent to the point where you sometimes are bored because you're searching for the same phrases over and over again, just in different variations. A couple of years ago, I was doing some legal research and I used the same keywords on Westlaw. And I thought, I must have found everything I could have on that particular area of law. I then went on LexisNexis. I used those exact same keywords and I found an additional 20 cases which didn't come up in Westlaw. So where you have access to more than one database, the results are not going to overlap. You need to take the time and you need to search from scratch again. You need to use different phrases. So instead of happy, you use happiness. Instead of sad, you use sadness. And just keep using different phraseology in order to find what you're looking for. Don't rely on one database, as I mentioned. Sometimes look on Google. When I did the Vis Moot, I found a case that fit the almost exact same fact pattern as the moot problem that came up. And it was a case from the Ohio Court of Appeals from 1987. And I had nowhere where I could find it or nowhere I could even come to know about that case, but for Google. I searched on Google, it showed up, and then I had to go through the process of trying to track it down because there was a reference to it where it said there was a case that had to do with a godfather and godparent in terms of an arbitrator and a counsel and a conflict of interest. That's all it said. But I then had to go find where it was, find out how to go look for cases that came from Ohio Court of Appeals from 1987 and read through it and see, was it useful for me? Turned out it was. Not only that, I ended up reading all about how godparents work and how the interrelationship between them are. And I just kept reading and reading and reading. Even if it's barely relevant, sometimes you just have to keep going deeper and deeper. And once you've done that, you'll hopefully find that you're in the position where you know what you're talking about. And that's what separates a good advocate from a great advocate. It's that you feel so comfortable about the knowledge of area of law that you're talking about, that it's easy for you to express what you're thinking and the conceptual legal basis behind it. And that's only possible if you read that authority, you read all the underlying authorities, you read the area of law around it, and you keep practicing those research skills every day. Keep in mind that the law changes on a daily basis. So even after you've handed in your memorials, you need to keep researching because you need to keep up to date with what the law is as it changes daily. By the time you get to oral submissions, the law might have changed from when you had filed your memorials. So you need to make sure that you are subscribing to different platforms like Lexology, where you can click to say you want to subscribe to arbitration related law. You can choose which jurisdictions you think are relevant to you in terms of your research. You might want to join the Herbert Smith Freehills case notes, which come out every week, every day. They're very handy. You can click that you want to join their, Herbert Smith Freehills actually have an arbitration subscription as well, where they send out latest information to do with arbitration law and cases. All right, and so that brings me to what happens when you get stuck in research. And this happens to everybody. I've had other barristers come up to me and say they're stuck. I've had other students come up to me and say they're stuck. I've had everybody in every walk of life come up say, I'm doing research, but I am stuck. What do I do? You need to break the problem down. You need to go back to first principles. You need to ask yourself, okay, all right, this is a very big picture conceptual legal problem. What are the simpler problems I can look at bit by bit and then work up to it? And sometimes that might actually give you the best answer. As mentioned earlier, I spent some time working at the Court of Final Appeal, so the Supreme Court in Hong Kong, and the Court of Appeal. And I will say that anytime I talk to a judge, they would always say the best answers are always those you get from first principles, because they fit together neatly and simply. So that brings me to the end of my PowerPoint presentation. What I was trying to do today was just give you an overview of the basic research skills that are out there and how to go about doing that kind of research. If you have any questions of something more specific you want to ask, I'm more than happy to answer any questions that come up.
Sir Karim asks, how can we discuss a research in a good way?
Can we discuss a research in a good way? I'm not quite sure I understand that question. Maybe, Karim, could you clarify what you're asking? All right, well, we have another question. Oh, sorry, we have, all right, we have, well, I'll deal with the first question from Alpesh Sharma. So I was asked, do I have any insights onto issue-based research? I do. So when you're looking at an issue-based research, what you want to do is, in my personal opinion, start with a textbook. Textbooks give you the broader scope and broader knowledge you need to ascertain what that issue is and how the law with regards to that issue works. When you read a textbook, and you shouldn't just read one, you should read 2 or 3 textbooks on that one particular issue. If there are more, read all of them. There's never a point where there's too much information when you're doing research. There is a point where you need to stop, though. That's a whole separate thing, because you at some point do need to write your memorial and put everything together in terms of pen to paper. But you start off with, as I mentioned, textbook research. And when you're going through it, read all the underlying authorities. Read them one by one, take your time, if they're relevant in the particular section you're reading about. And that's how I would start doing an issue-based research. After that, you can always develop and do further research and use keyword searches to try and expand on those particular things. And when you've read the underlying authorities, use those authorities and search them within the new databases that you're looking at and see how they've been applied in future cases. Have they been applied? Has that textbook been cited in future cases, that particular section? All right, I hope that answers your question. I'm gonna move on to Josiah Chan's question, where he says, how about civil law cases? Which database do I myself prefer? I prefer any database that works. I tend to actually go jurisdiction by jurisdiction when I'm doing case research. I normally start off, because I'm in Hong Kong, on HKLII, so the Hong Kong legal database. I then tend to go to the English one, so the BAILLII, so BILI. And then if I'm looking for German cases or French cases or whatever it is, I'll try and find their database as their civil law jurisdictions and see if I can find anything. Now, the difficulty is with a lot of these other foreign country jurisdictions is their decisions are in other languages. So unless you can read French or German, sometimes it's tougher to get through them. So the best database to use is Westlaw, LexisNexis, and Kluwer Arbitration. Quite a lot of them have translations and summaries of different cases, authorities, and sometimes in the relevant insight section. All right, that brings me to Ilna Khan's question. While doing research sometimes, the whole judgment is not available. How can we get access to those judgments? I've come across that a few times. You'll be amazed sometimes what you can do. I think when I did the Vis Moot, I needed a case from a jurisdiction, I can't remember where. And I ended up writing to I somehow learned who the counsel was on the case. And I wrote to that counsel and asked him, could he send me a copy of the case? The alternative is you'll be surprised at how skilled or well-versed your librarians are at university. Usually they have contacts in other jurisdictions or they know other librarians who might be able to help them. Alternatively, there's no harm just reaching out to professors in other universities, other countries, lawyers. The worst they can do is say no. And that's not the end of the world. All right. Oh, so going back to Kareem's question, I think they've now clarified it. If I'm doing research, then I want to discuss and make a good brief of the research to the attendees. What is the best way to present my research briefly and in a good way? Okay, I get it. The best way to do it is to write out your entire research or your entire conceit or concept that you've come up with in its fullest form. So you start off with it being in the most expansive version that you have possible. After you've done that, you cut back. You start seeing how is it best to tell that narrative, how to tell that point, tell that story, and where possible, how to summarize and make it more succinct. That's how you go about doing it. Now, it's a skill that you develop over time. I mean, even now, I still have to go through the process of where I write hundreds of words, and I need to go through a sentence and look at each word one by one and see, was that relevant? Does that help me? And does that tell the reader what I'm trying to tell them? And if it doesn't, the word needs to go away. You actually need to spend the time going through it line by line, word by word. But that's just about how to go about writing. In terms of research, how to present it in the best way, think about it as if you didn't know what the law was about, and I showed it to you for the first time in this document. Does it make sense to me? Does it make sense to you? Does it make sense to your parents? Dr. Sharma once had me practice for the Viz, and we were out and about, and we were just talking about how I would go about making my submissions, and he asked me to explain it to a stranger on the street. And I did that. And surprisingly enough, the stranger, Dr. Sharma asked him, so did you understand what Lavesh was saying? And he said, yeah, I think I got it. And sometimes if you can just explain it to your friend or just anybody who doesn't even know what you're talking about and they understand it, then you've explained it in the best way possible. All right, another 2 questions from Alpesh. Is it better to frame preliminary arguments at the time of the research? And if you could please share your research tips from international laws and rules. I found when I did the Viz, I tried to frame my thought process initially, and it was a bad idea. Because the reality is, I didn't know what I was talking about, and I didn't know enough to know how to frame it properly. You need to take the broad overview approaches, which is I'm going to read everything near or ancillary to the topic. And after I know what that area of law is and how it generally works, I can narrow it down and start making it into more understandable and applicable areas of research. Could I share some tips on international laws? Sure. A good tip is sometimes you just want to talk to somebody who's maybe from that jurisdiction or knows about that jurisdiction. For example, when I was doing research on German law that came up one time, I had to know what is the Landesgericht and in terms of what is the level of court. When I was looking at the Ohio Court of Appeals, I had a classmate who happened to be from America, and I asked him, how does the federal and state structure for American legal system work? And so you want to have that understanding so you can know which authorities are more authoritative and more important and which ones are less important. But at the end of the day, when you're doing research, treat everything as if it's important. only decide what you're going to cut and cull after you've gone through everything. In terms of research for international laws and rules, honestly, Google is your best guide. You'll find that most countries now have open access and open justice. They put everything at the forefront, and it's clear that you can access it. Can I suggest any commentary on the UNCITRAL model law? For the UNCITRAL model law, I actually think your best bet is to go and read through Clue or Arbitration, especially Gary Bourne's book, if you can get access to that separately, and go through that bit by bit. In terms of the UNCITRAL model law, if you give me a few minutes, it'll come back to me what the actual textbook is that's relevant in terms of just analyses of it. But there is a case digest that does exist, which includes the 2006 amendments as well, which I used all the time. So I would probably go back to the case digest when and where possible. All right. Is there anything else or any other questions or?
Sir, we have a few more questions. While getting to know about the area of law for the first time, how do we skim the relevant data from the entire law?
Well, okay, well, it's two separate issues there. When you're getting to know a new area of law, at that point, you can't really, I mean, you should still skim to some degree, but you don't really skim. You get the most basic textbook in that area of law that's possible, and you read it from start to finish. And I don't mean you have to sit there and read and underline every page. Just read it from start to finish. It really doesn't take that long. We all think it takes a lot longer to read and get through the material than it really does. I tend to get through a book or chapter very quickly in reality, because I'm not actually trying to think, oh, what does this line or this word in particular mean? I'm trying to understand the big picture. And when you've done that, you can then go back and have a conceptual understanding of what we're talking about. I hope that answered that question.
Sir, next up, we have, even while using such Boolean operators, how do we narrow down the research more out of the results of the search?
Well, so for example, if you're using Lexis or Westlaw, there is a section that allows you to refine your search, so you can add even more searches within it. But the reality is, I would go through when doing the Viz and read 100, 150, search results and click through every single one of them. I think there was one day where I sat reading a Google search I did, and it was 50 pages worth of Google results. Persistence, effort, and repetition are the key for research, honestly. There's no truer and trier method than just repetition, persistence.
Next up, it's the question, someone asked how to recognize the law applicable on a particular problem.
Well, when you want to understand what the law applicable on a particular question is, you're going to have to read the facts first. Now, before you can actually decide what is the applicable law, you need to know the facts. And you'll usually find that there's 2 or 3 parties, 4 parties, 5 parties, whatever they are. They're all from different jurisdictions, right? So you've already limited it to the point where you know one of those different jurisdictions are going to take place. The question is next, where did the transaction take place? And you want to look at what the applicable, what that law is. Then you want to go back and look at the governing law of the contract. Now, I mean, this is just a generic analysis. So this just gives you a bit of an insight as to what are the possible laws that might apply. To find out what actual law applies, the starting point is usually going back to the contract and seeing what the contract says the applicable or governing law is. Now, if that maybe doesn't help clarify the issue, you might want to then go see where's the seat of arbitration. And with regards to that, you might want to read, for instance, the case of Chubb and Enka and see how that applies and affects what law governs the arbitration agreement, as well as how that's intertwined with the substantive law that governs the contract.
Sir, Ozaya asks, what is the full name of Gary Bourne's book and which edition?
It's the 3rd edition, and it is international commercial arbitration.
If the attendees have any more questions, you may put them in the chat box.
If I remember, there's 3 of them. That's all right. I guess that's all the questions. Yes.
Sir, also someone asks a commentary for UniDraw.
Oh, commentary for UniDraw. There's, I don't know it off the top of my head. It's a small little book where you can actually find there's a commentary on UniDraw. There's also a few authors who've done some analysis and commentary on it. One of them being Michael Bridge, who's a professor from the London School of Economics, and he's written quite a good commentary on the principles that are applicable in UniDraw. But normally for the Vis Moot, you want to start off first looking at the CISG. But yes, there's also publication by the UniDraw themselves in which they do give a commentary on the UniDraw principles. Well, I see, yeah, go ahead.
If there are no further questions, with your permission, I would now like to conclude.
Sure, thank you. I just want to again thank you, both you and Dr. Sharma, for the invite and for allowing me to share some of my knowledge and experience in terms of how to do research for the Viz. But at the end of the day, everything I've said, just remember, keep typing different results and keep searching them over and over and over and over again, to the point where all you do is dream about the Viz. Yeah, eat, sleep, dream it, and you'll be fine.
It was an honor for us to have you present with us today. Thank you so much for taking out time from your busy schedule. We would also like to thank our interpreter, Miss Monica. We look forward to our future webinars and are extremely excited for the first Asia Pacific Vis Moot. Till then, I hope everybody across this forum keeps safe. Have a good evening, everybody. Sir, Rajesh, sir, if you do not have anything to add, we shall now end the meeting.
I just want to say one thing is that thank you very much, Lavesh, for sharing your information and knowledge. And it's so good to see that from a student's point of view, how you get into their mind, the way you started. So it connects very well. But apart from that, the big message, which I want to give it to all our attendees, and I also appreciate your effort in helping us in that sense, is that this moot is not just a pre-moot. It's not a pre-Vis moot for a practice or anything. This has a mission and it has a purpose. Through this moot, we want to include all our differently able people, generally we call them disabled people. We want to include them in the system so that all the students who want to be the arbitrator or arbitration counsel in future, just because of his or her physical condition, we do not want them to leave out. We want them to bring them in the flow. ICC has created a task force for including disabled people, a disability inclusive international commercial arbitration. But our argument or our approach is, or to connection with them is that unless until we train our students or all these students through the moot or through otherwise, then they cannot integrate into the professional life, because the professional life is even a cutthroat competition. So in order to prepare them physically, mentally, and intellectually, we have to start this practice even before. And therefore, this moot is not just a moot, it's a lab. It's a laboratory where we are testing, we are trying, we are using all sorts of techniques or tools which we have to include all students. All means all, and therefore our moot tagline is that disabled, inclusive, disability, diversity, inclusive Vis Moot, or the pre-Vis Moot. That's what we are calling. So if you look at that, in 30 years of my career, I have never presented anything with the help of interpreter, a sign language interpreter. In this one, we are trying to understand how we can communicate with other people with such kind of disabled. We don't call it disabled, we call it differently able people. That's what we are calling. So this is our humble effort, a kind of short or a kind of like, mission which we are following. And I'm very happy that all our speakers are coming forward and helping us and giving their time. So Lavesh, thank you very much. And thank you, Monica, for your time and for your help. So thank you. All our audience, if you are a student and if you have any student who have any kind of physical disability or anything, and they want to try out the Moot or want to learn this arbitration or the CISG or anything related to Moot, please bring them in. If you are not putting them in the competition, at least allow them to come here and try out. We will be helping them, and any assistance you need, we will give you that. Everything free, we will give it to you. So please include them, please bring them, and that's how we can make all these people totally create a level playing field for them. And that's how we say that this Moot is about inclusive to all. All means all. So that's our mission. So thank you, Lavesh, once again for your time today.
No, thank you for your admirable mission. And I think this will actually be a very big success. And I hope everybody has gotten something out of today in terms of the previous talk that happened about brainstorming and now about research. And hopefully that we've made your life a little bit easier in terms of understanding how best that you can succeed in this Moot or pre-Moot.
And another thing is that everybody has a right to know. It's not about the secret recipe for any one team or any one university. We want to share the recipe with everyone. And now it is for them to mix and match and try out and share and share with everyone. So it's a sharing is caring. That's our view.
Thank you, Barney.
Thank you. Thank you. Thank you.
Right.
Thank you for your time, Lavesh.
Cheers.
Bye-bye.
Everybody have a good night.
Thank you. Anything else, Faria?
No, sir, that's it. Thank you so much.
Have a nice day.
You too, sir. We shall now end the meeting.
Bye-bye.